with
latest
no
draft?
audio?
Or do you need
Oh
more
my
time?
God.
We
Can you
told the
hear me
jurors to
now?
be here at 11, so we have time if you need more
Okay,
time.
well, I'm going to have to cut out that entire beginning intro. Thank you so much, Goodwill, for telling me that. I hope you can hear me now. Okay, so the audio to the court is actually cracked as well. And you can see, on the note right there, they say audio. Thank you, Goodwill 619. You must be from San Diego, right? Thanks for letting me know. Okay. Oh my God, I literally thought I had this software down. Okay, turn on the mic. I guess step 2. Step 1, turn your computer on. Okay, so I have to look over here because I cannot move the, let me see. I'm gonna try and, I'm gonna try and watch the trial again over here. Shout out Goodwill.
Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning.
These jurors are
Well,
always
let me
late.
ask the defendant, you still plan on resting?
I do.
Okay.
Oh.
So when the jury comes in,
Yeah, so he
I'll
just asked
remind
her,
them that the state rested last Wednesday.
did she
And then
want to
I'll
rest her
turn to you and
case?
you'll,
Because they had gave her another
presumably say
opportunity
the
to pull her
defense
own
rests.
witnesses.
I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the.
Okay, I'm just gonna mute it and you can see the captions on the bottom. So, oh my gosh, sorry, I'm trying to pull it up so I can watch it in front of me. In addition to a dangerous, okay, let me turn the audio back on.
Anything else?
So they're waiting for the jurors to come in.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony.
Yeah, so Lori, they gave her the opportunity
All right.
to present more, again,
So-
to call her own witnesses,
How
and she
many
doesn't have
jurors-
any.
You can go ahead and print out.
So that's a big
Your Honor,
red
I have 2
flag.
issues I'd like
No
to
one's
bring
gonna
up
go on
real
the stand for her.
Go ahead.
The
So
jury
she rested
process
her
of the
case.
jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing 2 numbers out of randomly out of a container.
It's crazy how some of these things in our
And when does that get
Society
done?
or
How does that
Not
work?
till after the closing
very
arguments.
Okay.
So the alternates are
what's
told
the word, like,
that they're still alternates, they're not released. Because
Outdated?
I have had in the past jurors become sick or ill or not
she
be
just
able to
asked like how they
deliberate, and we have to
select
call
new
back an
jurors, and he
alternate
said
to
it's
deliberate.
literally
So
like
they're still under
pulling
the
a number out of a
admonition
hat.
until they're released.
So we're keeping
It's like
all
the
of them.
mail system, like when are they gonna
Basically.
figure
But
out
only 12 will
new
go back and
ways to do
deliberate.
things?
Okay.
If one of those 12 becomes
I guess if
sick
it
or
works,
is
if
unable
it's
to
not broken, I
deliberate,
guess don't fix it.
we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective England.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct? Correct. All right.
So is
Dang,
it just the
my
snippets that
mic
were
was off,
played
but I
all
totally
together?
talked about
It
her
should just be
interview
the
with the
parts
cop.
that were
We're
played in
talking about
court.
her interview with
Is
the
that
lady
correct?
cop. Right after her, they took her to the police station right after her husband was unalived the same day. And she was going back and forth with the lady
Right.
cop on the stand last week.
So did you have a question about that?
Yes, so is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
Oh my God. She had such an issue with this lady cop. And this lady cop was like, in my opinion, nice to her.
Right, portions have been redacted out. But it's just more or less what was played.
And they played, I
during
guess, a
testimony.
snippet. They played only
Does that
a
answer your
portion.
question?
Kind of, but Detective England testified that it was the full interview, so what does that mean if she testified that it was the full interview?
I don't know, it's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is gonna know it's redacted and they get the redacted exhibits instruction as part of the instructions, so either side can point that out to the jury that it's redacted.
I don't know why she
Anything
has
else?
such an issue with the lady that interviewed her, because that's
I
what
was
she's
just
talking
assuming that
about.
that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into, to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
When
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said, that was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that
Lori
actually
is
gets shown to the jury.
Just
Was there
throwing shots in the dark
was
right
that
now?
the case?
Was not for appellate purposes.
Okay.
But shout out to Goodwill69 for telling me to turn on my mic. I literally did a whole monologue before this started about the lady cop and Lori. And Lori is mad because they wrote in the document that the jury was going to see the entire interview of the lady cop and Lori talking right
Okay.
after the incident. They asked Lori to go to the station, the police station. They interviewed Lori
So
and they
the
interviewed
states
her.
closed their evidence.
Her now unalive daughter. They interviewed her 16-year-old daughter who was.
I'm just trying to find out
I'm
what
not
the
sure if
jury
she
is
was in
going to
the
be
house.
seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the
Kylie's
hearsay
her
parts
deceased daughter.
were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
Yeah, she's
So we
fighting.
have
There.
our Exhibit 20, the
A mute point right
defense's
now.
proposed Exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
Yeah, Lori is upset because they played a
Anything else?
portion
That's it.
All right, we're
her
getting
interview.
the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions.
So yeah, so right after the incident, right after her husband was found shot, they asked Lori if they could interview her in the police station, and she agreed. And her and her daughter, who is now unalived, her 16-year-old daughter, went into the police station, and they were interviewed by this lady cop, I guess Detective England from the Chandler Police Department, who was cross-examined last week. And Lori went in on her, like, and it's kind of that's she just does, her marbles just, things just don't connect with this lady, because she's, and I said it on my last video, she was literally treating like every single person on the stand was her enemy, when they're not. They're just there doing their job. You know, it's not their fault that you are in this situation. And Lori asked the cop on the stand last week, were you questioning me as a victim or a suspect? And in the interview, you can tell she was not being interviewed as a suspect. She was treated cordially. You know, they didn't have her there very long, and Lori was acting like it was just another day. She didn't even have any sort of emotion, and that was a red flag. You know, if they were questioning her as a victim, she didn't read the room. They did question her as a victim, and instead of, to me, this is like psychopathic tendencies. Lori was so fixated on trying to seem likable instead of realizing the gravity of the situation, instead of realizing an hour before her husband was shot and killed inside of her house. Even though they're separated, if you are not a monster, you're going to feel some type of way about that. But Lori didn't. Lori acted like it was another day, and she was complaining how her and Charles, or the guy that got murdered, were trying to figure out custody. She didn't even act like he was just wiped off of the face of this earth. So she did not read the room. She did not, you know, show any sort of remorse or concern. She was just like, okay, yeah, I'm here. She was laughing in the interview. To me, also, I feel like I watch a lot of body language videos, and she was doing Duper's Delight. Like, she did it as soon as they started. Like, she was sitting there and, you know, with the straight face, and then before you know it, she was smiling. And it reminds me of the Chris Watts interview, who I believe also is a psychopath, very detached from reality. Because if you guys are familiar with the Chris Watts and Shanann Watts murder families, or family murders, he was very detached from the situation as well. And they were both interviewed mere hours after the incident. And Chris Watts was being interviewed by these two detectives, and it seemed like his entire goal was to get them to like him, which in a normal, different situation, that would be perfectly normal. But in this situation, like, you're not reading the room. Your wife is missing, your children are missing, and you're sitting here trying to make them like you. Like, if you were really like understanding the gravity of the situation, that would be the furthest thing of what you were trying to do. You would be literally not, you wouldn't give a crap if these people liked you. You'd be upset, you'd be mad, you'd be sad, you'd be grieving, you'd be just hurt all around and stressed out and all kinds of things, but not like sitting there trying to get this person, this detective, even if it's a cop, like if you are not directly involved in the situation, you're not going to give a fuck what they think about you. And these two people, Lori Vallow and Chris Watts, when they got interviewed, and there was a difference though. Lori Vallow was interviewed as a victim. And so if you, let's see if we can pull up the, we'll have to pull up the interview. I don't know if she went in on the cop though when she had her on the stand, and she asked the lady cop, because the lady her name was Detective England. She asked her if when Lori was interviewed, she also interviewed Lori's daughter, who was alive at the time, Tylee. And this is one of the excuses Lori tried to kind of plant a seed as well, that her husband never got along with her 16-year-old daughter. So this somehow makes him a horrible person, which in fact, we don't really know the dynamics of the relationship. Like a 16-year-old female, that's a very like kind of rocky time, not rocky, but emotional time in a woman's life, or in a girl's life. You're growing up, like in any child's life, they're changing, right? So they could start defying authority or rebelling. So for her to just put that all on her husband and act like her husband was so evil because she wasn't getting along, they were clashing with her daughter. But now both are passed away. Now her daughter is gone, as well as her little boy, JJ, and her ex-husband. So Lori has a ton of bodies underneath her, and it doesn't really matter if she's found guilty or innocent at this point, or if there's a Mills trial. And I think that's what Lori was trying to do right now. She was trying to say that there was a piece of evidence that was submitted that was described incorrectly. The judge basically was like, tough shit, because you should have caught that. You can't say that now. Like, she was like, oh, over the weekend, I just saw an exhibit 286 that it says that you played my full interview with Detective England when it was just a snippet. And he was like, well, I don't know who said that. I don't think that they would put that's your full interview. She's like, yeah, that's what it says. And he goes, well, and a lot of people in the chat were saying, duh, they redacted portions of the interview because they did it like on behalf of Lori, because they don't want the jury to know that Lori has already been convicted of killing her two children. And in these interviews, they interview her daughter, who was alive at the time. So Lori is like so dumb and trying to act like this was some sort of mistake against her. But in reality, they don't want, if she had any freaking sense, she would know why they did that. They did that because how the hell they found 13 people that aren't aware of this case. I mean, I guess that's a possibility. There's still people that I talk to that don't know anything about the Brian Koberger case, which I have to tell them, and it's amazing to me. Maybe people just don't really like, they have heard of it and maybe they don't remember names. Because I'm like, oh yeah, I tell people about this YouTube channel. I'm like, oh, I'm gonna be following the Brian Koberger case. They're like, oh, who's that? And I'm like, wow, like you don't know who that is. And so, but then when I say, oh, he's the guy that they think killed 4 college students, then they kind of are more familiar. So they found 13 jurors that don't know about her prior convictions. And it's like the state, they followed the playbook, which I don't think I think that the jurors had a right to know. They have, in my opinion, they had a right to know, but there's this motion, or I don't know what they call it, a ruling or some sort of rule that is called 405B, where it prevents the courts from bringing up past bad acts. So meaning like this was part of Lori's past bad acts. And so there's a motion called 405B that they're not going to bring up things that you did before, but in which, okay, if I'm going to trial, yes, I want that. Of course, you want that. But this, if they're totally separate, like if it's like, okay, I'm going to trial for this, what she's on trial for, a conspiracy to murder. And let's say the bad act is she killed someone or she got into a wreck and had a DUI. That is kind of like a completely separate incident, having nothing to do with this current situation. To me, that makes sense. Okay, yeah, don't talk about that. It has no relevance. But these prior bad acts, she was convicted of unaliving her two children, her two innocent children, who her current husband is in jail, who has been convicted of, because they found the children buried in her current husband's backyard. So they prevented the jury from knowing this information, which is really crazy that they don't know this. Will they convict her based on just this little bubble of a situation, just hearing if she's going to be, convicted for this? I think the case brought a pretty good stack of evidence that she will be convicted. And if for some reason she's not, she's still going to go back to jail. She's still going to, spend the rest of her life in jail to pay for the crime she did against her kids. So I don't really know what the point of this trial is, honestly. Like, I guess, knock on wood, I'm not in jail. I haven't been charged with anything. And if I did, they're still giving you rights. They're still giving you rights to defend yourself on other charges. I don't understand I don't understand what the point of this is. She's going to be found guilty. Okay, they're giving her what, another 100 years? She found innocent. She's still got to go complete her first sentence for life. So to me, it's like this whole thing is just really kind of pointless. Her kids are never coming back. Her new husband is already in jail. They found her two children buried in his backyard. And I wasn't sure on how they were unalived. And I hate that term, by the way. But YouTube, I guess, wants you to say it that way. They need to add that word into the new dictionary for sure. Unalived. But yeah, so I Googled like how the kids were actually taken, and it is so sad. It is so sad. So they found both of them buried in the backyard, and the daughter was dismembered and burned. So they chopped her up and they tried to burn her they were trying to get rid of her body, basically. But they cannot determine the cause of her demise, because her body was so it was so badly decomposed, so they don't really know how she died. And they did say she was not burned alive, because she had no inhalation or smoke inhalation in her lungs. So she wasn't burned like to death or anything. They tried to get rid of her body after the fact. But her son, on the other hand, he was not dismembered. So it looks like they tried with Tylee and didn't get a great result. So when they unalived the son, who was 7, he was found with duct tape over his mouth and a bag over his head. And it's like so messed up. Like they say he fought for his life. He had a lot of like defense wounds. And can you imagine someone, your mother, putting a bag over your head and duct tape? Like, that's so terrible. Like, that's like, that's just sounds so, like, so cruel. Okay, so they have a poll here. I don't know if you guys can see it. It says, how long will Lori's closing argument go? Oh my God, 10 minutes, an hour, 2 hour, 30, 2 hours and 30 minutes. I'm gonna say an hour. Oh my God, she's gonna try and that was the other thing she kept getting reprimanded for in court, is like, instead of asking questions, she kept making statements. So they were saying, you're testifying. She was saying things to get them on record. And she did that on purpose, obviously, but they kept, objecting to that. Like, stop testifying. You're testifying. And then she was like berating the witnesses and making comments after they would say something super like unprofessional. But what can you expect? She's not a professional lawyer. I think that's going to hurt her in the long run. That definitely, the jury is going to stick with the jury. I think they're going to see right through the type of person that she really is, and she can't charm her way out of this one. Let's see what the judge is saying. Or in a brief phrase. So I think Lori's going to take this opportunity for her closing statement, and she's going to talk for a freaking hour. I'm going to say an hour. Let's see what the poll says. 32%. So 32% and 34% say 30 minutes. So definitely between half an hour to an hour. The opening statement was pretty long for both sides. Like, it's supposed to be a preview of what the jury can expect, but I guess I've never really watched a lot of opening statements, and both sides were like telling you everything that they were going to bring up. So I think they're going to hone in on
The
their
defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
So the prosecution, they cross-examined, and Lori jumped in and did her own questioning, but they asked her if she had her own like witnesses, and she rested. They gave her the whole weekend to think about it. They were like, because she couldn't decide, and she didn't have anyone to call and stand for her. So that's
Are we one? Oh, nope, we got it.
that's
Okay.
definitely like,
Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence.
Okay, some jury rules. That's gonna be hard. I mean, you're supposed to, like, there were certain things that they were like, strike that from the record. And it's like, how do you unhear something? So, yeah. Supposedly they only get paid like $40 a day too.
Consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given.
Okay, so they're reading the juror the final rules on the closing statements. If you guys remember Lori's opening statement, she was just like, the evidence will show. She kept saying that. The evidence will show. The evidence will show. Yeah, she did not prove that. The evidence showed that she was pissed that her husband was dating. She grilled the lady he had a date with the night before. She unalived him. She set him up. They played the phone call where she called his life insurance company, tried to figure out why her name wasn't the beneficiary. And that's not proving her guilt. You know, all of these things, some of these things can be interpreted in their own ways if you kind of analyze them individually, right? If you lose your ex-husband and he does have a life insurance policy, you may need the money. There's no judgment on that. However, you know, the fact that that was like her main concern, I guess. I forgot where I was going with that, but you know, so she had to face all of these people. She had to face his sister on the stand, and his sister, she even over answered some questions, and Lori had a habit of asking every single person on the stand. The last question she would ask them was, did you ever see me talk or hear or read a text, or I can't remember how she worded it, that I conspired to kill my husband? And they were all like, no, because none of them had, you know, in black and white seen that or read that. But people have intuition. But his sister, she was the only one that instead of saying yes or no, she was like, no, but I've seen a ton of other evidence that shows that you did. So she like added those extra words on the record, and I know that stuck with people. That stuck with me.
Judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience.
I would be falling asleep if I was a jury right now. Oh my God. I'm not an audio listener either. I mean, I don't know a lot of people that are, most people, but I think they have a copy that they're reading along with the judge as he's reading it out loud. But that would be so hard to follow. This is like a professor lecturing you, and I'd be tuned out already. I've already tuned out. So the juror is not listening to half of this shit right now.
Decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such.
Wow, that's interesting that they said that, because that was what Lori kept focusing on, the fact that the lady cop that just literally had the most like non-confrontational conversation with her. Again, Lori asked her, was she questioning her as a victim or a suspect? The cop said as a victim, and the judge just said right now, like the jury cannot analyze those conversations as, how they say sometimes they make, cops will make a defendant, or when they're questioning them, they'll intimidate them and you'll give a false statement. So that's kind of what the judge is saying.
Proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty.
Wow, the judge is really fair. She's got a good judge. I mean, she definitely got lucky with this, because he's like, I mean, I guess these are normal rules, but he's really explaining to the jury that, just because she was there doesn't make her guilty. Like, that's crazy that he said that.
Find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching.
Oh, damn. So they're like touching on all of these things. Like they just said, don't question why other people aren't present in the courtroom. The brother that shot and fired the gun, not present because he's dead. So he's really kind of explaining to the jury, like, literally make up your own mind if you think she's guilty beyond a reasonable doubt. I don't think that there was room for unreasonable doubt. I think that the evidence does point, there was too many coincidences. Too many.
Another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short.
She wanted to kill him. She wanted to kill him because he was about to confront her about her crazy religious beliefs. And that was presented in court. So there was motive. However minuscule and really definitely not a good reason to unalive someone. Like, who cares if somebody was trying to give you an intervention? Like, you could just tell them to kiss your butt, and like, she could have divorced him. She said that he didn't want to divorce her. So you think that you're going to get away with wiping him off of the face of this earth? Like, that's not going to work very well. Let's see what the chat says. The chat says motive was money. The chat in the court. Lori is going to be innocent, someone says. Nor do I agree that Joe Ryan's death was natural. Hubby number 3. Ooh, Joe Ryan. That's her first, like, her older son's father. He's not alive either. This lady is definitely a serial killer. She looks scared to death with her shoulders brought up like that. Yes, she's wanted that life insurance payout from Charles' policy, but others have thought she killed before for the same reason, but maybe also the power trip. I agree with those saying that Joe Ryan and Alex Cox deaths were not natural. I don't think Alex Cox, her brother's death was natural. I don't think any of these people's deaths were natural. It's just too much of a coincidence. And when there's too many coincidences, it's not a coincidence.
You should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following 2 conditions.
So the judge has his own closing statements. Oh my God. This is okay. I knew this was going to take a couple hours. Wow, these are so many rules.
Ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger.
So her brother, who shot and killed Charles Vallow, the deceased, who she is on trial for conspiracy, her brother Alex Cox is the one that actually pulled the trigger. He tried to say it was self-defense, which was proven to be BS, in my opinion. Or the state tried to, hopefully that the jury came to that conclusion, because he was shot in the heart. And usually in self-defense is you diminish the threat. You fear for your life. Supposedly the story is he was swinging a bat. When they proved that, because he was a semi-professional baseball player, you know, and Alex, if you see the camera footage, the body cam footage of exactly right after when it happened, the cop shows up. Alex Cox calls 911. 45 minutes later, he comes outside. He's like holding the back of his head. There was no blood, and he's claiming that Charles had just swung at him with the bat. But he doesn't really even have an injury. And he shot Charles, and they said Charles was actually left-handed, and they put the bat in his right hand. Like, Oh my God, people, like, you can't get away with killing someone. You just can't. Like, there's just too many things that you're going to overlook. So, such as that. Okay. So, he was a semi pro baseball player. They try to say he swung a bat at him. Turns out that's not even his swinging side of his body, swinging hand. And then he was shot again, and they could tell, the medical examiner could tell the second shot happened after he was already lying on the ground. So that was not self-defense. The threat had already been, diminished.
The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, one,
She's going to be found guilty.
physical force was necessary to protect against another's use, attempted use.
Let's see what the chat is saying about this. Why did these righteous people have to kill their children in such a gruesome way? Lori Dumbbell. They call her Lori Dumbbell. Serial killer. Yep. Obviously plotting Charles' demise. Closing coming after lunch. Oh, I hope not. I guess if they go to lunch, then we're gonna have to take a break. After this, they're going to lunch and then closing arguments after around 1 o'clock. Ah, damn. All right, guys. So these are the jury instructions. I guess they're gonna go to court after this. This has been our Lori Vallow trial crime watch. I have to come up with a cool name for this. But thank you guys for tuning in. I'm gonna shut this down then, and we're gonna come back in an hour, because they said that the closing arguments are gonna be at 1. Alrighty. Okay, yeah. It says update. After this reading, the court will go into lunch break. They will return at 12:45 for closing arguments. The 30-minute video delay is still enforced on us by the court. Oh shit. Okay, so they're gonna return at 12:45, but it's 30 minutes after, so they're not gonna return until 1:15. All right, guys. Thanks for tuning in, and I'll see you the next one.